Hi there, this is Jonathan Ginsberg, and I want to talk to you today about what should seem to be a fairly simple concept, and that is surrendering property in Chapter 7. What happens when you basically have an asset in a Chapter 7, you can't afford it anymore, and you want to just walk away from it? You'd think, again, no big deal. And sometimes it is no big deal, but sometimes there are complications. And so I want to talk to you today first about the simple cases, and then in a subsequent video we're going to talk about when there are problems that arise in Chapter 7, and then we're also going to talk in another video about what happens in Chapter 13. So let's start with the simple cases in Chapter 7. You file bankruptcy, you have an asset. It could be a house, it could be furniture, a vehicle, jewelry, whatever the case may be. You cannot afford it. You want to just walk away from it. Well, technically what happens is when you file bankruptcy, something called a bankruptcy estate is created. What that means is that all of your assets become part of your bankruptcy estate. The estate is administered by a trustee, so that anything you want to do while the case is still open has to be approved by the trustee. So that's kind of just some base knowledge there. And you file bankruptcy, you want to surrender property. The trustee looks at it and says there's no equity here, the property is underwater. Let's say you owe $15,000 on a $10,000 vehicle, or you owe more on a piece of furniture than it's worth, which is typically the case. Basically what happens is the trustee says, I'm going to abandon my interest in this property. When the trustee abandons interest, basically the lender now has the right to take the property back. The lender will then sell it. Any deficiency claim will be wiped out in Chapter 7 because it's unsecured. You're done. You move on down the road. Simple case. That's the way it should happen, and that's the way it really does happen in most situations. Let's reverse the equity situation, and this is one of the things I want you to be aware of, and that is why it's so important to declare even property you're surrendering as exempt if exemptions do apply. Situation would be one where, let's say it's a vehicle, it's worth $15,000, you owe $5,000. There's $10,000 of equity. Why would you surrender the vehicle in that case? Well, it may be that the vehicle needs repairs, or you simply just can't afford it, you've lost your job, whatever the case may be, you can't sell it for whatever reason. You want to surrender the equity, surrender the property. Well, in that case, your bankruptcy now becomes an asset case. It's not a no asset case because there's equity for the trustee to liquidate. The trustee will say, well, I'm not going to abandon my interest in this, I'm going to go ahead and liquidate this asset. The trustee then takes the asset, files motions with the court, notifies the court this is an asset case, files motions to get permission to sell the vehicle, any other assets there may be, sells those assets, and comes up with a chunk of money that's sitting in an account. Well, if you've declared part of your asset as exempt, which again you're allowed to do, even if you're surrendering, you get a check back. So for example, if you've got $3,500 of exemption available on that motor vehicle, you declare that in your bankruptcy schedules. When the property is liquidated, you'll get a check back for $3,500. So that's why it's really important, even if you're surrendering property, to make sure that you declare anything you're surrendering as exempt, so that if there's equity there, so you'll get some of that back. The remaining equity, the trustee will then go ahead and distribute to creditors. The trustee will then send out notices to all creditors, file your proofs of claim. Creditors file claims. Trustee then files more paperwork to determine who gets what and when they get it. You'll get paper for the next 2 years, and so your case will kind of be lingering for 2 years, even though for all intents and purposes your discharge is done and you're done, but you'll still get paperwork for the next couple of years. And again, if you're going to get an asset, any sort of exemption back from that asset, it may be 2 years before you see any money. The lender won't get any money back for another couple of years as well, although they can't contact you, they can't bug you or anything like that. You'll have no personal liability, but you'll just get a lot of papers. So main thing to take away from all this is if you are surrendering an asset and there's equity there, make sure that you and your attorney declare whatever exemptions are available to you as part of your bankruptcy petition, so that you'll be able to liquidate any exempt property. When the trustee does sell the property, you'll get your money back. So these are the simple cases, just to be kind of baseline knowledge about how it works when you surrender property. Next, I'm going to talk about what happens when you have a property and you surrender it and there's a problem, and you get stuck with liability even though you surrendered the property. Sounds crazy? Stay tuned for the next video. Again, my name is Jonathan Ginsberg here at Ginsberg Law Offices. Any questions, please let me know. Thanks a lot.